There are two forms of child custody in Minnesota, legal custody and physical custody. The courts must make a determination on both forms of custody. Legal custody by definition means the right to determine the child's upbringing, including education, health care, and religious training. It is presumed to be in the children's best interest for the parents to have joint legal custody. And in the vast majority of cases, the parents either agree to or the court orders joint legal custody. It really becomes the burden of a parent who is pursuing sole legal custody to come forward with significant evidence why the other parent should not receive legal custody of his or her children. This usually comes down to a parent either having a major alcohol problem, drug addiction, a major mental illness, or in the case of an abusive relationship. And in fact, if domestic abuse has occurred between the parents, then the presumption actually switches to provide that joint legal custody is not in the children's best interest. However, even if a parent does not receive legal custody of his or her children, that parent still has the right of access to and receive copies of school, medical, dental, religious training, and other important records and information about the children, and has right of access to information regarding the children's health and dental insurance. That parent also must be informed of the name and address of the children's school and be entitled to attend parent-teacher conferences. However, schools are not required to hold separate conferences for each parent. Further, if a parent does not receive legal custody, the parent is also entitled to reasonable telephone communication with the children and must be notified if a child is in an accident or has a serious illness. Legal custody is determined based on the best interests of the child factors, which are discussed in a separate webinar.